Protection from abuse order respondents, or the person against whom a PFA was filed, may be ordered to have evaluation, including attendance at an orientation, with a DVCC certified provider within 2 weeks of being served with a protection from abuse order. The evaluator may recommend completing a domestic violence intervention program and will determine whether participation should be in an individual or group setting. They may also make recommendations for other types of treatment that address mental health or substance use. The result of the evaluation will be shared with the court. The respondent's compliance with the domestic violence evaluation order and following recommendations will be monitored by the court in monthly compliance hearings. As written in the protection from abuse order, the respondent must be evaluated by a DVCC certified treatment program within 2 weeks of the date of this order, or from the date this order is served, and follow all recommendations for treatment. The respondent shall show on demand proof of compliance with the ordered treatment to the court. It is mandatory that the respondents comply with the recommended treatment and attend monthly compliance hearings. PFA compliance hearings exist so that the court can monitor compliance and progress with the recommended treatment. At each hearing, the litigant will meet with a family court judge who will ask them about their progress, what challenges they may be facing, making it difficult for them to comply with the DV evaluation or treatment, and the changes they have seen in themselves as a result of the program. These hearings allow the court to interact directly with the PFA respondent to talk about the respondent's compliance with the PFA order. The hearing is not an opportunity to re-argue the PFA petition or to make any changes to the underlying PFA order. PFA petitioners or the person who filed the PFA are not given notice and not expected to appear for these hearings, but they are entitled to updates on the respondent's compliance and progress with the evaluation and treatment order. Petitioners can get updates by contacting the court or the Domestic Violence Intervention Program directly. At each PFA compliance hearing, the judge will explain the purpose of the hearing and the benefits of the Domestic Violence Intervention Program.
The purpose of the compliance calendar is to monitor your progress as you proceed through domestic violence intervention treatment, as ordered in your protection from abuse order. Domestic violence intervention treatment has been proven to change behavior in a positive way. You may not want to go at first. That has been an experience that I have seen and experienced over the course of this calendar. But if you keep an open mind and you attend your sessions with a willingness to change, you will benefit from your time in the program.
During the introduction, the judge will also explain that there may be consequences for anyone who chooses not to comply with the evaluation and treatment order.
If you are not complying, one of the sanctions that I have available to me is to extend your protection from abuse order. Another sanction is that if you are held in civil contempt of court, I can enter a monetary fine against you on some period, for example, daily, weekly, or monthly, until you do comply. And then in the ultimate cases where people are just not going to comply with this court's order, we can incarcerate for civil contempt, which means that you will be incarcerated until such time as you demonstrate to me that you are going to comply with the court's order.
When preparing for court, there is a business casual dress code and hats are not allowed. Phones must be silenced for the duration of the hearing. Respondents should bring with them any documentation they've received from the treatment provider. This may include information confirming their attendance at the orientation or evaluation, a letter from the provider that states what treatment, if any, has been recommended, and any letter or certificate of completion. When speaking in the courtroom, you may only speak when addressed and directed by the judge. It is important to note that the judge should never be interrupted and always be addressed properly. Compliance and progress will be monitored during these monthly hearings until the respondent completes the recommended treatment program.
Litigants may request to appear virtually or continue their hearing. Requests to your hearing officer must be made 2 weeks before the scheduled hearing. Litigants can file to request via Zoom or to motion for a different court date. These requests will be decided by a hearing officer, and until they are granted, litigants are expected to appear as scheduled. These forms can be filed in person at Family Court or through the PFA mailbox. For more information, please contact Family Court in your county.
Once the court receives notice of completion, the respondent will be discharged from the PFA compliance hearings and will not be required to appear in future monitoring hearings. However, unless otherwise noted by the judge, completion of the domestic violence intervention program and release from the compliance hearings does not change the PFA order. In most cases, the other provisions mandated in the PFA order will remain in effect until the expiration date on the order. In conclusion, the goal for monitoring compliance in this way is to help people connect and engage in treatment services designed to change behavior, improve relationships and communities, and enhance victim safety.